Be ready. Start. This court is not the forum in which these conflicting claims may be debated. Whether there is a genuine need for banking facility in the rural sector, whether certain classes of the community are deprived of the benefit of the resources of the banking industry, whether administration by the government of the commercial banking sector will not prove beneficial to the community and will lead to rigidity in the administration, whether the government administration will eschew the profit motive, and even if it be eschewed, there will accrue substantial benefits to the public, whether an undue accent on banking as a means of social regeneration, especially in the backward areas, is a doctrinaire approach to a rational order of priorities for attaining the national objectives enshrined in our constitution, and whether the policy followed by the government in office or the policy propounded by its opponents may reasonably attain the national objectives are matters which have little relevance in determining the legality of the measure. It is again not for this court to consider the relative merits of the different political theories or economic policies. The Parliament has, under entry 45, list 1, the power to legislate in respect of banking and other commercial activities of the named banks necessarily incidental thereto. It has the power to legislate for acquiring the undertaking of the named banks under entry 42, list 3, whether by the exercise of the power vested in the Reserve Bank under the pre-existing laws results could be achieved, which it is the object of the act to achieve, is in our judgment not relevant in considering whether the act amounts to abuse of legislative power. This court has the power to strike down a law on the ground of want of authority, but the court will not sit in appeal over the policy of the parliament in enacting a law. The court cannot find fault with the act merely on the ground that it is inadvisable to take over the undertaking of banks, which it is said by the petitioner by thrift and efficient management had set up an impressive and efficient business organization serving large sectors of industry. In R.K. Garg case, it was observed that greater judicial deference must be shown towards a law relating to economic activities due to the complexity of economic problems and their fulfillment through a methodology of trial and error. As noted above, it was also clarified that the fact that an economic legislation may be troubled by crudities, iniquities, uncertainties, or the possibility of abuse cannot be the basis for striking it down. The following observations, which refer to a couple of American Supreme Court decisions, are a limpid enunciation on the subject. Another rule of equal importance is that laws relating to economic activities should be viewed with greater latitude than laws touching civil rights such as freedom of speech, religion, etc. It has been said by no less a person than Holmes J. that the legislature should be allowed some play in the joints because it has to deal with complex problems which do not admit of solution through any doctrinaire or straitjacket formula, and this is particularly true in case of legislation dealing with economic matters where, having regard to the nature of the problems required to be dealt with, greater play in the joints has to be allowed to the legislature. The court should feel more inclined to give judicial deference to legislative judgment in the field of economic regulation than in other areas where fundamental human rights are involved. In the utilities, tax and economic regulation cases, there are good reasons for judicial self restraint, if not judicial deference to legislative judgment. The legislature, after all, has the affirmative responsibility. The courts have only the power to destroy, not to reconstruct. When these are added to the complexity of economic regulation, the uncertainty, the liability to error, the bewildering conflict of the experts, and the number of times the judges have been overruled by events, self limitation can be seen to be the path to judicial wisdom and institutional prestige and stability. It is not the domain of the court to embark upon uncharted ocean of public policy in exercise to consider as to whether a particular public policy is wise or a better public policy can be evolved. Such exercise must be left to the discretion of the executive and legislative authorities as the case may be. The court is called upon to consider the validity of a public policy only when a challenge is made that such policy decision infringes fundamental rights guaranteed by the Constitution of India or any other statutory right. What has been said in respect of legislations is applicable even in respect of policies which have been adopted by Parliament. They cannot be tested in court of law. The courts cannot express their opinion as to whether at a particular juncture or under a particular situation prevailing in the country any such national policy should have been adopted or not. There may be views, opinions and opinions which may be shared and believed by citizens of the country, including the representatives of the people in parliament. But that has to be sorted out in parliament, which has the approve such policy. Thank you.